My name is Balint. I'm a researcher at the Ferenc Madol Institute. Thank you for the interesting presentation. So, my contention is that, on the one hand, in the presentation of Dr. Šmiglová, the mechanisms are too soft. Soft law is not enough. And on the other hand, soft law seems to appear in a position of being almost too powerful, or having some consequences that are not that welcome. So it's interesting that we have to settle somehow this question, and I do think that soft law is powerful, and it is powerful also in the human rights and the humanitarian law sense, but there is some insufficiency with how we analyze it. And I think in the question of rule of law and democracy, because the two are often used together, and they are used in a not quite a juridical but more in a political sense, these have been used for a long time as arguments for sort of suppressing different countries' wills. And if we take a look at the history of international economic law, which I enjoy researching, we can see that at one point the rule of law was actually a question of who is China allowed to buy drugs from, right? And with reference to the Opium Wars. So basically my question is, do you think that the EU should be looking at all into questions that are basically political? Or should it frame it more in a legal sense? And if it frames it in a legal sense, do you think that it should become then mandatory and should come with not even recommendations, but more precise indications as to what member states should be doing? Thank you.
I think that you are right, when you mentioned that we are coming to different conclusions when it comes to consequences of these soft law instruments. But I think that one thing is significantly different here, and that's the environment. Since my colleague, she was referring to United Nations, which is a conglomerate of, how many, 200 states? And many of them simply do not care what the United Nations say. Whereas within the European Union, we are integrated. The intensity of the integration is on a completely different level, and what the others say and what the European institutions say does matter. So within the European Union, the soft law in many times acts as a hard law, and that's why we have to take it carefully and examine it carefully. And when it comes to your second question, I believe that less is more in the case of the European Union. So I'm not in favor of any extension of its involvement in the area of rule of law. I don't think that that's its mission. I still believe in Council of Europe as the primary tool for human rights protection and rule of law protection. But that's my personal view.
Thank you. I agree with the point that the membership is very important. As for the UN, there are many states that they have decided to become a state party to all those conventions enlisted just to be a state party, but they do not actually follow their commitments almost at all. As for the charter-based mechanisms, they are obliged to submit the report. There is the universal UPR, Universal Periodic Review, and they submit their reports. They meet, their discussions, but this is really political. As for the recommendations, it's different from the UPR because they know they have to go there. As for the reports for the committees, sometimes there are delays. Sometimes even the initial report is not submitted. And what is very interesting on the other hand is, for example, the general recommendations. I've been thinking about the topic for my blog, because there's been, for example, a proposal for general recommendation of the CEDAW, protection of women, 33, and they included in the text, terminologically speaking, a legal duty of a state party to do something. And there was a big discussion like, it does not, you cannot interpret that convention this way. There is no legal duty for a state party to do it. So you as a body, a convention body, you cannot somehow invent it in the text. So the proposal was changed. Nevertheless, there is also the issue of the so-called, I'm not sure about English, but in German, competence issue. So these committees are trying to well, they are asking state parties, of course, to fulfill their obligations, and they do. I mean, all the states have problems with human rights protection. It does not mean that there's any state saint. Nevertheless, the conventions were adopted in a certain way, and committees are happy that the states are state parties, and they are trying to work in that environment. And it depends on the membership. And it's completely different attitude to human rights protection here in Europe if you compare it to Asia, when there is no regional human rights protection system. So that's, I think, the starting point.
Perhaps one last remark. The question here is also who controls the one that control? Who should control the European Union? Since if you look at the general definition of the rule of law, I believe that the European Union, unfortunately, has many issues, many problems that should be addressed, and somehow its focus is just on member states and not on these problems. For example, transparency of legal regulation, or if you deal, for example, with direct effect of European Union law and directives, you see that nothing is clear here. The issues are, or the principles are set by a court of justice without any direct legal basis in founding treaties, and courts of member states deal with these principles even within one state in a very different way. So I believe that we should start with the European, that the EU should start with itself and then perhaps focus on other issues. But yeah.
Maybe it is a question for me, but I intended to put it to Ahmed, this question. So there were some ECJ judgments against Romania concerning this decision 928 per 2008, the mechanism of verification and cooperation. And in the first decision, in the operative part of that first decision from 18th of May 2021, there is an interesting, let's say, phrase. In that, the ECJ puts something the following. If a constitutional court interprets a certain constitutional provision in a way that it contradicts the decision of the European Commission on the mechanism of cooperation and verification, the courts should apply the mechanism and disapply the constitutional court decision. So this is point number 7 of the operative part. For me, it was always very difficult to answer to this problem raised by the ECJ. You mentioned that this decision, the first, the third, and the fourth part of these decisions are very abstract. General policy, you said. So how can a judge from an ordinary court assess that a certain constitutional court decision is in contradiction, is not in line with this decision? So this is my question, let's say.
This is one of the questions in which a real conflict raised between the European Court of Justice and the Romanian Constitutional Court, which is not really known outside Romania, and mainly authors who are writing about this conflict are very favoring the ECJ's point of view. Practically, it is complicated because we have this kind of reports, which progress reports or technical reports, and mainly the progress reports are in question, which were actually published by the Commission, and the ECJ practically said that the national judge at a court may disregard the national norm or Romanian Constitutional Court decision if they contradict the report. Because practically the question was put in such a way that this report is something which is mandatory. It has a generally obligatory character or not, because the decision itself is so vague, it cannot be controlled. It's just very broad interpretation. And the tool for interpretation of that very general benchmark is nothing else than the report by the commission which was published. So, and the Constitutional Court, in my point of view, in Romania, very correctly said that it is not acceptable. So this is not acceptable. But this is practically a part or a very specific fight between some constitutional courts and the European Court of Justice regarding the primacy of EU law, what are the limits of the primacy of EU law, how this concept can be integrated into the national constitutional order. So this is something which I think we will debate it, I don't know, in 10 years as well, or 15 years or 20 years from now on, because if this tendency continues, the questions and problems which give rise to the same interpretation issues will broaden, and we will have more and more such conflicts. So the clear answer is in my opinion, these reports has no mandatory force. The decision itself, it has, but if a national judge is obliged to apply the report to the decision, that is too much, because it gives mandatory force to the report, which is not acceptable.
So my question would be related to the Venice Commission's rule of law checklist. Given that there is no connection between the Venice Commission, the Council of Europe, and the European Union, but the EU, especially the European Commission, draws inspiration from the rule of law checklist developed by the Venice Commission. So my question would be whether there is some indirect impact of the Venice Commission for Serbia's accession to the EU, considering that the rule of law is a significant pillar of the Copenhagen criteria as well.
The answer is definitely positive to your question, but I cannot say from the perspective of Serbia, honestly, how much we as state officials in Serbia are aware of the importance and the context in details of that checklist of the rule of law. In my opinion, we should be aware. We should go step by step in, if I can say, checking those sub-benchmarks in those general benchmarks. I think that it is a very useful and legal way which we should, and I can say we must go by this way. And from the EU, also honestly, I think that all those requirements for the checklist of the rule of law is also, in case of Serbia, very marginalized, because I don't want to talk to initiate the political debate, but it is unfortunately very, very clear that there are some political, if I can say, prerequisites, some preconditions or conditions which should be followed, which should be fulfilled in case of Serbia, in order to accelerate the EU integration. So as a lawyer and also as a judge of the Constitutional Court, I would be very happy, I will be very happy if in the future the checklist of the rule of the law of the Venice Commission will be a document, more referential document in Serbia for Serbian authorities, as well as the Constitutional Court of Serbia, but also to the other side, to the relevant factors of the EU, in order to evaluate Serbia's process of integration in a more objective and more legal way. But of course, we all know that politics and law are not only in the interplay, but it is also the law which is always in its background, its politics. So that is how it is, how it works. It works like that in the past, and unfortunately, or fortunately, we don't know, the political process will be always more important than the law in the future. That is the question. That is my answer.
I would like to have a question, a general question to actually both of the presenters. So I was thinking that when the German Federal Constitutional Court has an ultra vires decision, it tends to be accepted because they say that the German standards are generally higher than the EU standards when we think about fundamental rights protection. So what is your opinion in a hypothetical case in your national constitutional court's practice, whether it would be accepted an ultra vires decision from the side of the EU, or what is the difference between the German ultra vires decisions?
Okay, thank you for the question. Yes, it is a question of controlimity theory, in which the German Constitutional Court developed 3 limits in applying the EU decisions, the EU law. It is about constitutional identity, it is about ultra vires, and it is about the level of protection of fundamental rights. You ask what is the difference between our Eastern or Central European courts' decisions and the German one. Everybody knows the Weizmann decision from 5th of May 2020 of the German Constitutional Court. Germany has, as you know, a pretty tough, powerful constitutional court, and this puts Germany in another paradigm than our, let's say, constitutional court. Basically, we have actually the same constitutional legitimacy, but in practice, it seems that the Central European Constitutional Court's decisions may be more easier overruled. I cannot hide that, as concerned the Romanian Constitutional Court, we applied the theory of constitutional identity from 2012. We have the first decision in which we mentioned this. And we were talking about constitutional identity in a decision of ultra vires, in a decision from 8th of June 2021. It was not seen very well by the ECJ. I can tell you that the ECJ disagree with a kind of unilateralism. So for the cooperation with the ECJ is not to affirm you as a constitutional court the constitutional identity, but you have to ask that if that problem is a question of constitutional identity. I may refer to a question, a preliminary question posed by the, I think, by the Latvian Constitutional Court, a question of the language policy, education in Latvian or other languages. So when it comes about the application of controlimity theory in the courts, we do not have that powerful negotiation power than like Germany. Basically, we apply the same doctrine. We are aware of the doctrine of controllimity from Germany, from Italy, but actually we cannot negotiate with the ECJ from the same standpoint.
Thank you for your question. So I will just say briefly, Croatia has 4 million inhabitants. So we are a really small country, and if we compare ourselves to Germany, it will not be good for us. But you may call me naive or think that I'm naive, but I really want to believe that things have been changed in meantime, and that a good reasoning of the good decisions can make the point. So, thank you.
Just one remark that you made reference to the population in Croatia, and it came to my mind that if there will be EU enlargement, for example, with Ukraine, who has much, I don't know exactly, but comparable population to the biggest countries in the EU. So would it change the situation, or it's more the still that the center of power in the EU is concentrated on Germany, obviously. So I think it's interesting.
As we know, a lot of the rationale of the Court of Justice of the European Union or the European Court of Human Rights comes from German legal literature or German legal practice. I can recall the proportionality test. It was first applied in Germany, so it was a kind of transplant made by the court from Strasbourg and then from the court from Luxembourg. So Germany has, let's say, a privileged relationship with the ECJ and the European Court of Human Rights due to its legal heritage and its power to influence by ideas the way in which these two courts assess the diverse problems that they have to do. And maybe, it's not always about the number of population or the let's say, the area of a country, but sometimes is a problem of legal background and to be very consequent in what you are doing. So if today you will affirm constitutional identity in a certain problem, and tomorrow and the day after tomorrow you are silent, it means that you are not consequent with your prior decision.